Hello and welcome to SANDEMY.
This series explains housing law, standards, and the Renters' Rights Act in clear, accessible language without getting lost in legal jargon or headlines.
We're not here to give legal advice or take sides.
Instead, we focus on how the housing system actually works in practice for tenants, landlords, letting agents, and local authorities.
In this episode, we're looking at how renting and eviction will work under the Renters' Rights Act.
Let's get started.
It's great to be back. We've talked before about the big ideas in the Act, but today feels like we're really getting into the mechanics of it. You described it in the notes as the structural spine of the whole thing. We're talking about the new tenancy structure.
That's right. And it might sound a bit dry, tenancy structure, but this is the engine room. This change is what drives everything else. All the talk about ending no-fault evictions, it all comes from this fundamental change to the contract between a landlord and a tenant.
Okay, well, that's exactly what I want to get into first. Forget the headlines for a second. Practically, what is changing on the actual piece of paper? When someone signs a tenancy agreement in this new world, what are they actually signing up for?
To really get the scale of the change, we have to look at the old world for a moment. For more than 30 years, the default for renting in England has been the assured shorthold tenancy, the AST.
Right, the standard 6 or 12-month contract pretty much everyone is familiar with.
Exactly, and the clue was always right there in the name, shorthold. It was designed from the outset to be time-limited. So as a tenant, you got security for a fixed period, 6 months, a year, maybe 2 if you were lucky. But the key feature, the thing that made the whole model work for investors, was that once that fixed term was up, the landlord had an automatic right to get the property back.
And this is where the famous Section 21 notice comes from, the no-fault eviction.
Precisely. It was a calendar-based system. The logic was just, the time we agreed is up, so I'd like my asset back, please. The landlord didn't need a reason. They didn't have to prove you'd done anything wrong or that they were selling. They just pointed to the date on the contract and said, time's up.
So it was almost like a very long hotel booking. You book for a set duration, and at the end of that time, you have to leave if the owner says so.
That's a great analogy. It treated housing as a temporary asset, a temporary service. Under the Renters' Rights Act, that model is, well, it's deleted. The fixed-term tenancy is abolished for the private rented sector. Instead, all new qualifying tenancies will be periodic from day one.
Periodic. Okay, we need to pin that down. For someone renting a flat, does that just mean it's a rolling contract?
Yes, but it's the implication of that rolling contract that matters so much. A periodic tenancy runs from one rental period to the next, so usually month to month when you pay your rent. Crucially, there is no end date written into the agreement.
So I don't sign for 1 year. I just sign for now.
You sign for now, and it continues indefinitely. It just rolls over month after month forever, unless one of two things happens. Either the tenant gives notice to leave, or the landlord uses a specific legal ground to end it.
Wow. That feels like a massive psychological shift.
Yeah.
You're going from, I have this flat until next June, to I have this flat until I decide to leave, or something goes wrong.
It turns the property from a temporary stopping point into a genuine home. It's a fundamental shift from time-limited occupation to ongoing occupation. That security of tenure is now open-ended. It gets rid of that ticking clock feeling that so many renters have lived with for decades.
I have to ask about the scope of this. Does it apply to absolutely everyone? You know, if I'm renting a room in a shared house, or I'm a student, or renting a luxury penthouse, does this act capture all of that?
It captures the vast majority, yes.
Yeah.
Qualifying tenancies is the legal term. It covers almost all standard private residential lettings in England. But you mentioned students, and that's a really common question. The source material does highlight some specific exclusions.
I'd guess that purpose-built student halls are different from, say, a shared house on a normal residential street.
Spot on. The purpose-built student accommodation, those big blocks owned by universities or large providers, they're generally excluded. They work on licenses or different tenancy types because, well, they need to empty out every summer for the next academic year. It's a completely different institutional model.
But what if I'm a second-year student renting a standard 3-bed terrace from a private landlord?
Then you are very likely under the new system. That would be a periodic tenancy.
That seems tricky for the landlord, doesn't it? If the students decide they want to stay forever, or even just for an extra month into the summer, how do they get the house back for the next group in September?
That has been a huge point of debate, to be fair. The general thinking is that if you're a private landlord renting out a residential home, you are providing a home, not just a term time service. However, there is a specific ground for possession just for student lets to help manage that cycle. We'll get into the detail on that next time. But the key takeaway is that the fixed term mechanism is gone for them too. Other exclusions are things like holiday lets, obviously, and some specific types of social housing which have their own rules.
Okay, so for the general market, the accidental landlord, the portfolio investor periodic is the only option on the menu. You can't write a fixed term into the contract, even if both you and the tenant want one.
No, you can't contract out of it. If you write, this is a 12-month fixed term on a contract after the implementation date, that clause is legally meaningless. The law will simply read it as a periodic tenancy.
Right, that is a hard reset. So let's look at the power dynamic here. I can imagine some tenants might hear the word indefinite and feel a bit nervous. Sounds heavy. If I sign this, am I trapped? Can I never leave?
It's actually the opposite. The flexibility is now weighted very heavily towards the tenant. Tenants keep the ability to give notice. It'll probably be 2 months, though that's being finalized, and then just leave. They aren't trapped at all.
So if I move in, and 3 months later I get a job in another city, I can just give my notice and go.
Yes. In the old fixed term days, you would have been on the hook for the rent for the full 12 months unless you had a very specific break clause. Now you're only tied in for that notice period.
Okay, so the tenant can hit the eject button whenever they like. But the landlord, they lose their eject button.
Correct. And that's where the rebalancing comes in. The landlord loses the ability to just say, the contract is over, please leave. The simple passage of time is no longer a valid reason to seek possession.
They lose the reset button.
That's the perfect way to put it. The end of the fixed term was a natural reset point, a clean slate. Now, to end a tenancy, a landlord must rely on a statutory ground for possession. They can't rely on the calendar, they have to rely on the law.
Statutory ground for possession. It sounds very formal, and frankly, a bit intimidating for a landlord who just wants their flat back. I've heard people ask, does this mean it's the tenant's house forever? Can I never sell it?
I've heard that fear too. Have I lost control of my asset? And the answer is clearly no. Possession rights haven't disappeared, they've just been structured. The act isn't about forbidding evictions, it's about requiring a reason for them.
Legitimate reasons.
Exactly. If you want to sell the property, that's a legitimate ground. If you want to move back in yourself or have your parents move in, that's a legitimate ground. And of course, the fault-based grounds are still there. If the tenant stops paying rent, damages the property, or causes antisocial behavior.
Okay, so the reasons all sound perfectly reasonable. If I want to sell, I can evict. If they don't pay, I can evict. So why is there so much anxiety around this change in the industry?
Because the process of using those grounds is fundamentally different from the old Section 21. There are 3 massive shifts in how this works in practice. This is where the rubber really meets the road.
Okay, let's walk through them. What's the first shift?
The first is the shift from automatic to grounds-based. Under the old system, you served a form, you waited 2 months, and as long as the paperwork was right, the court had to grant possession. It was mandatory. Now, you have to state your reason. I am seeking possession because of Ground 1A, sale of property.
So every single eviction notice now has a because attached to it. You have to show your hand right from the start.
You do. You have to be transparent. And that leads directly to the second shift. The procedural burden. It becomes much more technical. Notices have to be on the correct prescribed form with the exact notice period for that specific ground.
And are the notice periods all different?
Yes. Some grounds might need 2 months notice, some might need 4 weeks, and for, say, severe antisocial behavior, it could be immediate.
And if I'm a landlord doing this myself and I use the wrong form, or I give 4 weeks notice when the law says it needs to be 4 weeks in a day,
then your notice is invalid. If it ever gets to court, the judge will just throw it out.
and you have to start the whole process all over again.
Back to square one. Reserve the notice, wait the full notice period again, pay the court fees again. The margin for error on the admin side has basically gone. With the old system, because you didn't need a reason, the paperwork was simpler. Now the paperwork has to be flawless, and it has to prove your point.
Which brings us to the third shift. Proof. Scrutiny.
Yes, greater scrutiny. This is the big one. Who is checking your homework?
Well, the judge, presumably.
The courts, absolutely. When a case gets to court, the judge isn't just rubber stamping a date anymore. They will be looking at whether the ground you've claimed genuinely applies.
What does genuine look like in court? Let's take that selling example. Can't I just say, Your Honor, I'm thinking of selling?
That's probably not going to be enough. The court will want to be satisfied that the intention is real. They might ask, have you engaged an estate agent? Is the property listed online? Do you have a memorandum of sale? If your only evidence is, I had a thought about it yesterday, you might struggle to convince a judge to make a family homeless.
So you can't just say, I'm selling to get rid of a tenant you don't like and then quietly put it back on the rental market a week later at a higher rent.
You absolutely cannot. And this is where the second layer of scrutiny comes in. The local authorities, the councils. The legislation gives them powers to investigate misuse of these grounds. If a landlord claims they're selling, gets possession, and then immediately relets the property, that is a misuse of the system.
You've lied to the court or the tenant.
And it carries very heavy penalties. We're talking about potential rent repayment orders where you have to pay back months of rent to the tenant and significant fines. It shifts the whole system from possession at will to possession with cause.
This sounds like it completely changes the job description for a letting agent or a self-managing landlord.
It really does. It moves the job from being about administration to being about active management.
Because before, if you had a tenant who was, let's say, mildly annoying, not criminal, just difficult. Maybe they pay the rent a week late every month, or they're a bit rude to the neighbors. The old way was just to wait for the fixed term to end and not offer a new one.
It was the path of least resistance. A quiet, conflict-free way to solve a management problem. You didn't have to confront the issue, you just waited it out.
And now?
That path is closed. You cannot evict someone for being mildly annoying. If they're in rent arrears, you have to prove it. If they're engaging in antisocial behavior, you have to prove it. We're moving to what I'd call evidence-based management.
Evidence-based management. That sounds like something from a corporate training manual. What does that actually mean for a landlord on a Tuesday morning?
It means you are building a case file from day one. Take rent arrears. You can't just have a messy spreadsheet or a history of text messages saying, where's the rent? You need a clear, professional rent schedule showing exactly what was due, what was paid, and on what date.
And for behavior, that seems much harder to document.
It is harder, but it's essential. If a neighbor complains about noise, you can't just ignore it. You need to log it. You need to write to the tenant formally. Dear tenant, a complaint was received on this date regarding loud music at 2 a.m. Please desist. You must keep a copy of that letter.
Because if you eventually have to go to court for antisocial behavior, that letter becomes your Exhibit A.
Precisely. If you stand before a judge and say, they were noisy, the judge will say, prove it. If you have a diary of incidents, copies of 3 warning letters, and a statement from the neighbor, you have a case. If you have nothing written down, you have no case.
So the era of the hands-off landlord is effectively over. The one who just checks their bank account once a month and tries to forget about the property.
I think so. You're managing a relationship that is indefinite. You have to actively manage issues as they arise because you can't just wait for the clock to run out. It rewards professionalism.
It sounds like a lot of work. But I suppose for the good landlords, the ones who really care, they were probably doing this sort of record-keeping anyway.
That's the hope. A good landlord communicates clearly and keeps good records. This law just turns that best practice into a mandatory requirement. If you're doing it right already, you have nothing to fear. If you're disorganized, you're in trouble.
Okay, the big logistical question. When is all this actually happening? When do we tear up the old contracts?
The key date for the private rented sector is the 1st of May, 2026.
The 1st of May, 2026.
Yeah.
Is that a hard cliff edge? Does the world just change overnight?
It is a very significant date, but the transition has a specific rule about possession. It all hangs on the date you serve the notice.
Okay, walk me through that timeline.
If a landlord serves a Section 21 notice, the old no-fault one, before the 1st of May 2026, the existing rules still apply. That notice is valid, assuming it meets current rules, and the court will process it under the old system.
Even if the court hearing itself ends up being in June or July of that year?
Yes, because the legal notice was served under the old law. However, if a landlord waits until the morning of May 1st to serve a notice, well, the old Section 21 is gone. They can't use it. They must use one of the new grounds we've discussed.
And what about the contracts themselves? If I'm a tenant in a fixed term that runs until December 2026, does my contract stay valid until then?
No. The fixed term evaporates on that date. On the 1st of May 2026, all existing assured shorthold tenancies will convert to assured periodic tenancies by what's called operation of law.
Operation of law, that sounds like magic. It just happens automatically without anyone signing anything.
Exactly. You don't need a new contract. You don't need to meet the tenant to sign a new piece of paper. The law simply steps in and says, this is now a periodic tenancy. The fixed end date is no longer binding.
Wow. So by lunchtime on May 1st, the entire private rented sector in England has shifted to this new system.
With one exception. Social housing. The source notes a later implementation date for private registered providers of social housing expected sometime in 2027. But for the private landlords and agents listening, your deadline is May 2026.
That gives people some time to prepare,
Yeah.
a decent runway.
Yeah.
But when you think about the scale of operational change needed, changing software, training staff, rewriting all the templates, it's not actually that long.
It's really not. If you're an agency with 500 properties, you need to be reviewing your systems right now. You need to know how you're going to gather the evidence we talked about. You need to be training staff so they're not giving out the wrong advice.
So we've covered the death of the fixed term, the rise of the periodic tenancy, the new possession rules, and this intense new focus on evidence. If we had to boil this down for our different listeners, what's the one main takeaway for each of them? Let's start with tenants.
For tenants, the headline is security. Your home is your home for as long as you want it, provided you follow the rules. You get predictability. You can't be asked to leave just because a date on a calendar has passed. But, and this is vital, it is not a free pass. You still have to pay your rent, you still have to be a good neighbor, or the landlord can and will get possession through the courts.
And for the landlords and agents?
For them, the headline is diligence. You can still manage your asset. You can still sell it. You can still evict bad tenants. But you cannot be lazy about it. You have to be deliberate. You need to keep records. You need to know the law. The autopilot function is broken. You actually have to fly the plane now. It's a business that requires evidence and compliance.
And finally, for the local authorities, the councils who have to police this new system.
For them, the headline is investigation. This new tenancy structure underpins all their enforcement work. When a council gets a complaint about an eviction, they're no longer just checking if the dates on a form are correct. They have to ask, is the reason given for this eviction genuine? It requires a much deeper level of inquiry. They are the guardians of the system's integrity, making sure the grounds aren't abused.
It really is a whole new landscape. It feels like the amateur end of the property market, the people who perhaps didn't take it as seriously, is being forced to grow up very, very quickly.
That is the direction of travel. The professionalization of the sector. It rewards good management and clear communication, which, frankly, should have been the standard all along.
And I suppose one final thought to leave people with is that while the process of eviction is getting harder, the core reasons for eviction, not paying rent, antisocial behavior, are still very much there.
They are. And interestingly, because landlords can no longer fall back on the easy no-fault route, those specific fault-based grounds become much more important. Landlords will likely be quicker to formally address arrears or behavior issues because those are now the only levers they have. You can't just let things slide and wait for the term to end anymore.
Which brings us perfectly to what we'll be discussing next time. We've talked about the structure today, but next time we're going to lift the bonnet and look at the grounds themselves. Which ones are new, which have changed, and how on earth do you prove them? That feels like essential listening.
Absolutely. If the tenancy structure is the car, then the grounds are the keys. You need to know which key works for which situation, or you simply aren't going anywhere.
That brings us to the end of this episode of SANDEMY.
We hope this has helped explain how this part of the housing system works and why the changes matter in practice.
This content is provided for general educational purposes only, does not constitute legal advice, and is not published on behalf of any local authority or organization.
For specific situations, always refer to the legislation or official government guidance.
If you'd like to follow the rest of this series, you can subscribe to the channel for future episodes.
In the next episode, we'll look at Can Landlords Still Evict Tenants? Grounds for Possession Explained.